Judges of appeal. For the fifth petitioners, I appear together with Lydia Mwalimu and Millie Odhiambo not in court. Okiya Omtata will appear in person. I think that is in order. My name is Professor Tom Ojenda, Senior Counsel, just for record so that I don't come back.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, my Lady, my Lords of the Supreme Court, my name is George Oraro, appear for the Attorney General.
Madam Chief Justice, Madam Deputy Chief Justice, Judges of the Supreme Court, my name is Jan Mohammed. I appear with Mrs. Wambugu for the second petitioner when you had consolidated the cases yesterday.
Your Ladyship, the Chief Justice, members of the court, together with Tom Masharia, Njoki Mboshe, Steve Wandeto, John Njomo, and Paul Kiragu, I am Paul Nyamodi for the third petitioner.
You may please, my Lady Chief Justice, Deputy Chief Justice, my Lady Justice Njoki Ndogu, and my Lords, I'm Mutieno Willis. I do appear together with Mr. Nelson Osiemo, Ms. Caroline Kituku, Ms. Lea Chanimbanga, and Mr. Victor Oduol for the fourth petitioner.
May it please you, my Lady Chief Justice, my Lady the Deputy Chief Justice, and the Justice of the Honorable Court. My name is Degwanjiru, together with Mr. Mituga and Mr. Morara. We appear for the fifth petitioner.
My Lady, my name is Ochiel Dudley for the International Commission of Jurists as Amicus Curiae, the second amicus. I appear alongside Mr. Isaac Okero and Ms. Anne Ngige. Thank you.
May it please the court, my Lady the Chief Justice, the Deputy Chief Justice, and other judges of the Honorable Court. My name is Kibe Mungai, appearing for the seventh petitioner alongside Ms. Wairimo Keru.
Honorable Chief Justice, good morning. Members of the court, on behalf of the Law Society of Kenya's amicus, my name is Stephen Mwenesi. I am in this matter alongside the President of the Law Society, Mr. Eric Theuri, and we have a team of the Public Interest Litigation Committee guided by Counsel Maura Kabata and Dr. Musau and Dan Oino Kemo and others. I thank you for allowing us to participate.
Thank you very much. We have taken the appearances. We will straight away go to the petitioner's case.
It may please the court, I'm going to deal with issue number 6 amongst the 9 issues that were crafted by the court for purposes of determination. And yes, and my learned friends, Mr. Firoz Norji, will deal with the issues captured in number 8 and 9. And my learned friend, Mr. Mwangi, will deal with the issue number 6. My learned friend, Mr. Philip Murgor, will deal with the issue number 1, 2, and part of 3. And my learned friend, Ms. Julie Soweto, will deal with the issues 3, 4, 5. I appear together with my colleagues for the first and second petitioners in the consolidated petition. The petition was filed on the 22nd of August this year, following the declaration of the results of the presidential elections that were held in the general elections on the 9th of August 2022. And those results were declared on the 15th of August 2022. Following that declaration, the petitioners, the first and second petitioners, were aggrieved with that announcement and consequently filed this petition. The petition is accompanied with a host of affidavits, and it may please the court, I'll refer to about 5 or 6 affidavits in my address. But as a matter of opening, I would want to deal with some constitutional issues as set out in the various articles of the Constitution. My lords and my ladies, after many years, the Kenyan people came about with the Constitution 2010. They enacted this, the Constitution 2010, and as opposed to the previous occasions, we had a constitution which was enacted by the people, in which they declared their sovereign authority. Therefore, anything done in the name of the Republic, in exercise of powers that spelled out in the Constitution, is based on donated or delegated authority as set out in Article 1 of the Constitution. Now, my lords and my ladies, it is important to put into consideration Article 2 on the supremacy of the Constitution, together with Article 3, which talks about the defense of the Constitution. As opposed to the previous periods when we had a Constitution which was negotiated at the time of independence with the colonial authorities, this Constitution established a republic in which the doctrine of separation of powers was embedded. And more particularly, my lords and my ladies, in this Constitution, there are several constitution bodies and agencies that were created, which includes the first respondent, the Independent Electoral and Boundaries Commission. And in accordance with the dictates of the Constitution, the Independent Electoral and Boundaries Commission, just like any other body established under the Constitution, and for that matter, any person who resides in the Republic of Kenya is required not only to recognize the supremacy of the Constitution, but act in accordance of the Constitution and in defense of the Constitution. Under Article 249, all independent offices and independent commissions are required to respect the sovereignty of the people and also to promote constitutionalism. This is important because Article 249 as read with Article 88 of the Constitution, which vests powers on or to the Independent Electoral and Boundaries Commission, requires that those powers must be exercised in accordance with the Constitution. Now, my lords and my ladies, the story that emerges out of the events that occurred on the 9th of August this year, and subsequently following to the 15th of August, upon the declaration of the Constitution, of the elections, the presidential elections, goes contrary to the established provisions in the Constitution, and will enumerate those violations at the appropriate time. But in opening, I want to say this, my ladies and my lords, that this grievance that we place before you, the highest court in the land, is not just a conspiracy theory. It is not just any ordinary event. If you look at the evidence that is placed before you in totality, we invite your lordship to come to the conclusion that what happened on the 9th of August this year and the subsequent events that followed on the 15th of August mark a pattern of violations against the Constitution in order to undermine the authority of the sovereign will of the people, and in effect preside, that is the commission, preside over an election that in effect did not represent the will of the people of Kenya. Now, in saying this, my ladies and my lords, you will be taken through a host of evidence borne out in the affidavits that show clearly that the Electoral Commission, just like they did in 2017, did not preside over an election that was in accord with the requirements of the Constitution as laid out in Article 81 of the Constitution. Article 81 of the Constitution requires that an election held in the Republic of Kenya should abide by the general principles set out in that article, and more particularly Article 81 Article 81E, that the elections must be free and fair, and Roman 4, the elections must be transparent, and Roman 5 of that article, that the election should be administered in an impartial, neutral, efficient, accurate, and accountable manner. My lords and my ladies, I want to emphasize the words accurate and accountable manner. And those provisions in Article 81 read together with Article 86, which requires that at every election, the Independent Electoral Commission shall ensure that whatever voting method that is used, the system is simple, accurate, again, the word accurate, verifiable, secure, accountable, and transparent. And more importantly, that the votes cast are counted, tabulated, and the results announced promptly and that is at the polling stations. My lords, you would notice that as we appear before you today, we have something that has never happened in this country, that you have a commission that is divided right in the middle. That speaks to a dysfunctional constitutional body that is not capable, leave alone the transgressions that we are going to talk about. But we are talking about an electoral commission that is dysfunctional and cannot be able to preside over an election that would give it the stamp of legality and legitimacy as spelled out in the Constitution. And I think that is a matter that this court should not disregard. And we'll come to that a little later in our address. Indeed, the Tower of Babel has been brought down by the appearance of two factions within the commission before your lordships and my ladies. And this, in event, has created a situation where no Kenyan can believe that the pronouncement of the first, of the ninth, I think the second respondent, Mr. William Samoei Ruto, as president-elect, came out of circumstances as envisioned in the Constitution of the Republic of Kenya. And your lordships, we would invite you, and my learned friends are going to address you on this point as to what really happened within the commission. Now, coming to the subject matter that I'm going to address you on in the question of the issue number 7, that states that the declared president-elect, whether the declared president-elect attained 50% plus 1 vote of all the votes cast in accordance with Article 138, sub-Article 4 of the Constitution. We want to persuade you that the second respondent never attained that constitutional threshold. And going back to the Constitution on that particular article, Article 138, sub-Article 4, it was made part of the Constitution by the framers of the Constitution to give legitimacy to anybody elected as president, to the effect that he had widespread support of the Kenyan people, and that is evidenced by the requirement that the president-elect must have at least 25% of the votes cast in each of the more than half of the counties. We are not dealing with that point. We're dealing with Article 4A, that it is a requirement, mandatory requirement, that the person elected as president must receive more than half of all the votes cast in the election. Now, talking about numbers in those two provisions speaks to the need for accuracy and accountability to give an election the legitimacy that the holder of that office would carry while exercising the powers of the President of the Republic of Kenya. And it's not an idle matter, because we went through an experience, before the enactment and proclamation of this Constitution, that a person would be elected by way of a simple majority, and in circumstances in which you would find that the person elected as president did not garner more than half the votes which are cast in a presidential election. So this is an important matter. And the difficulty about this particular article is that it requires at the end of an election before the declaration that the Commission carries out some mathematics, some mathematical calculation and computation based on proper returns of the votes that were cast in the polling stations and transmitted, as it were, the results thereof to the National Tallying Center and verified accordingly in terms of the Article 38 and the Elections Act. Now, my lords and my ladies, my starting point would be the fact that in this election, it was declared that, and that is found in paragraph 7 of our petition, that the second respondent in the declared result garnered 7,176,141 votes, which according to the Electoral Commission represented 50.49% of the votes cast in the election. Now, this figure would be correct depending on the calculations that were carried out or computation done by the Electoral Commission based on the votes cast during the elections held on the 9th of August 2022. Now, the complaint on this in this particular regard is contained in paragraph 43 to paragraph 48 of the petition. And for purpose of clarity, with your permission, my lords and my ladies, I would want to read out those particular paragraphs of the petition so that I can properly put it in context. Paragraph 43 avers that the number of voters who turned out to vote in the general election held on the 9th of August 2022 remains indeterminate. The second respondent has been issuing contradictory figures on the voter turnout. On the 9th of August 2022, on or about 1600 hours, 1 hour before the close of polls, the first respondent reported through various public news media outlets the voter turnout around the country was fairly low and was at an average of 52% of the registered number of voters. On 10th of August 2022, at or about 13 hours, in his first media briefing to the public following the close of polling, their second respondent announced that the total voter turnout in the general election as captured in the electronic voter identification kits, that is the KIM kits, was 65.4%, equivalent to 14,466,779 voters. Roman 3, the second respondent, however, indicated that he expected the above number to rise once the number of votes identified manually was taken into account. Contrary to the above declaration and reasonable legitimate expectation, The final voter turnout captured and declared in the final results of the presidential election in Form 3C is stated to be 213,137 votes, which is absurdly lower and not higher as anticipated. Notwithstanding a computation using addition of the valid votes in figures for the presidential elections, candidates in the aggregate results shows that the total number of valid votes is 14,213,027. Now, my ladies and my lords, the first point that is being made there, that if you look at the results as announced by the Electoral Commission and what is stated in Form C as the turnout of voters, and that is 14,213,137 votes. If you compute or add the number of votes cast for each candidate individually, that is the petitioner, the second respondent, and the two other candidates, that the figure that results is not the figure that was stated in Form 34C. The figure is 14,213,037. That is the first point. And this is important because as we proceed, we are going to demonstrate that the number of voters who took part in the elections and the number of votes cast in the election is indeterminate and is a moving target. It keeps on shifting. And I invite your lordships and my ladies to look at the results as set out in Form 34C and I equally invite the court to calculate the number of votes garnered by each of the presidential candidates. The figures do not agree at all. And therefore, the first point of reference, as it were, is that the computation of the figure 50 plus 1 was based on a wrong computation of the total votes cast, as it were, and as proclaimed by the chairman of the Independent Elections and Boundaries Commission. Now, this may be a mathematical paradox or even a conundrum. The numbers of voters who turn out to vote as declared by the Independent Electoral and Boundaries Commission should be the same as the number of voters that are declared emanating from the KIMS kits, because the source of the number of voters that have cast their votes can be garnered in two ways: by looking at the numbers as recorded in the KIM kits, or at the end of the election exercise by computing the number of votes cast in the election. And my ladies and my lords, you would find that in this election, again, if you take the number of votes, or rather of the voter turnout, which was 65.4%, 65.4%, as against the number of registered voters in Kenya, that, my lords and my ladies, would give you the figure of those who turned out to vote, because the percentage of the registered voters who are declared as having turned out to vote must be the same as the number of voters actually whose votes are counted as valid votes cast, and of course minus what are characterized as rejected votes. So, my lords, if you look at that particular point, and we're going to go through this one, you will find that the chairman of the Electoral Commission, in his announcement of the final results as borne out in Form 34C, and his announcement of the turnout of voters, which are recorded as at 65.4%, is at variance. And therefore, his calculation of the results based on the percentages cannot be correct. In this exercise, I invite you. In this exercise, I invite the court to look at the affidavit of one Edgar Ouko Otumba. That affidavit is two affidavits, a supplementary affidavit, and the first affidavit, which he filed on the 22nd of August. And my lords, in that affidavit, he makes a case, and Mr. Otumba has got a doctorate degree in applied statistics from Maseno University, and indeed he did assist this court in the previous petition in 2017. And he talks to the difficulties, that confronts us in terms of the various announcements that the chairman of the Electoral Commission made. And he states that on the 9th of August 2022, the respondent issued a communique, that is on paragraph 10 of his affidavit, on the day of the election, that the total voter turnout at 4 p.m. nationwide was at 56.17%. And that statement update is annexed to the affidavit sworn by the second petitioner, Madam Martha Karua. Then at the close of the voting, the first respondent again issued a statement that the total number of voter turnout based on the KIMS kit was 65.4%, which culminates in a total of 14,466,779 votes. And that communique is borne out in the affidavit again of the second petitioner. In an affidavit that is sworn on behalf of the petitioners, first and second petitioners, Mr. Nyangasi Oduo, in his affidavit, he talks to the Form 34C, and I'd referred to this earlier, where the total number of vote cast is 14,213,000. Now, the same Mr. Edgar Otumba saw a supplementary affidavit on the I think this affidavit was sworn on just a minute. on the 20th of August 2002. And I invite you, my ladies and your lordships, to look at this affidavit, because it analyzes several scenarios, including scenarios where the rejected votes are not computed, and scenarios where the declaration made by the chairman of the Electoral Commission as to the manual votes which were cast, which were recorded 86,889, and where those votes recorded as manual votes are computed together with the votes that were transmitted electronically. And then scenarios that would include the constituencies where the votes were declared later, including Ella's constituency. Now, the central point, and I want to make this point again, that the case that we are trying to make out is that if you look at the declaration made by the chairman as to the voter turnout, that will give you, as a percentage of the total number of registered voters, it will give you the number of voters that turned out to vote in the election, as opposed to another way of arriving at the same result, simply counting the number of voters that were recorded to have voted and cast their vote in the election. It is an equation that must agree in a mass submission. If the total number of voters that take part in the election do not agree with the votes that are counted as cast in accordance with Article 138(4), if they don't agree, then it means that the results of that election are not accurate, they're not transparent, and they're not accountable. And therefore, I'm inviting your ladyship and your lordship to go through this affidavit of Mr. Edgar Uko Otumba, because he lays out clearly there's several scenarios in which it is quite clear the second respondent, one William Samoei Ruto, could not have garnered 50% plus one of the vote cast in the election. And since all that is in our submissions and is in the two affidavits that are referred to, I invite your ladyships and your lordships to go through, and you find that it is indeed very compelling, the analysis given out by Dr. Edgar Otumba. Now, your ladyship and my lords, I'd also invite you to look at the affidavit of one Celestine Anyango Opio, and in that affidavit, which enumerates several constituencies, including Chepalungu and many others, where in terms of the results as transmitted to the public portal, there was a systematic deduction of the votes cast for the first petitioner, and the same number of votes that were deducted from the petitioner were added to the votes of the second respondent. And the unique thing about this scheme is that the number of votes cast, the total number of votes cast remained the same. The difference only was to the extent that the same number of votes that was deducted from the petitioner were given to the second respondent. And I leave that, Your Lordships, to look through when you retire, because the Form 34As in respect of those particular polling stations attached to the affidavit of Celestine Anyango Opio. There is also the affidavit, two affidavits from Arnold Ochieng Oginga, and this is particularly important because it contains discrepancies of the results in several areas, and in voter turnout in Form 334C and the KIMS kit. And all this, my ladies and my lords, taken in totality, would affect the results of the elections. In paragraph 16, up to the end, he goes out analyzing areas where there were discrepancies, and you would notice, my lords and my ladies, that in totality the discrepancies accounted for votes which are more than 140,000 votes. And in our submission, that has an impact on the result of the elections as declared. And I invite your lordships and my ladies to look at those particular analysis and annexures attached to the affidavit of Arnold Oginga. In the same way, in a further affidavit, Mr. Arnold Ochieng Oginga carries out an analysis in response to the responses to the petition by the respondents. And my lords, again, you would notice the number of votes that were being manipulated in order to secure a result that would favor the second respondent. And we have attached the relevant documentation, the forms showing the results, from 34As, 34Bs, those particular forms, and finally the Form 34B, which is a collation of votes at the constituency tallying centers. Now, my lords, I would conclude by saying that unlike many elections, this particular election, there was deceit, there was manipulation, and all this was premeditated and made possible by the attack, if I may put it that way, on the IT structure and system of the Electoral Commission. The way that the Commission was able to deal with the forms when uploaded and downloaded, staged, transmitted, deleted, all this in totality, if you look at the case we put before you, my lords and my ladies, set out in the affidavits that I referred to, shows an election that was rigged in favor of the second respondent. And on that basis, my lords, we urge that you nullify the elections on the basis of the fact that the second respondent did not attain more than 50% plus one of the votes cast in the election. I thank you. I now invite Ms. Julie Soweto to deal with the second limb of our submissions.
Good morning, my ladies and my lords. I will deal with issue number 3, 4, and 5 as identified by the court, and that is whether there was a difference between Forms 34A uploaded on the IBC portal and the Forms 34A received at the National Tallying Center and Forms 34A issued to the agents at the polling stations. I will start with that issue. My ladies and my lords, the evidence that we supply for that issue is contained. First of all, the complaint is at paragraphs 81 to 91 of the petition, and the evidence is contained in the affidavits of Celestine Anyango, Arnold Ochieng Oginga, Benjamin Agina, and Benson Wesonga. My lady, in Celestine Anyango's affidavit, the complaint is made that in 41 forms from the polling stations that she looked at, the Forms 34A received by the petitioner's agents vis-a-vis the Forms 34A uploaded in the IBC portal and those brought to the tallying center are different. The sampled forms were from Bomet, Kiambu, and Kakamega counties. The evidence is at page 18 to 106 of the affidavit of Celestine Anyango. My ladies and my lords, this evidence should be considered together with the evidence in the affidavit of Benjamin Agina, sworn for the petitioner, paragraph 9. Which deals with the Forms 34A that the IEBC had stated it would procure, and the features in those forms that should have been used in the election. It is our contention that what the IEBC set out to procure is not what they procured in the first instance. Therefore, we cannot even match the forms that we have and that have been provided in the election to what they had set out to procure. We have stated in paragraph 110 of the petition, from paragraphs 108 to 110, that the IEBC procured 2 parallel sets of Forms 34A, marked booklets 1 of 2 and 2 of 2. It was intended that only booklet 1 of 2 would be used at the polling station, while booklet 2 of 2 was to be placed in a tamper-proof envelope and not to be used at the polling station. The forms that have been transmitted, of the forms that were used to transmit the results in this election 2022, do not meet the standards or conform to either of the forms that the IBC said were going to be used, and this evidence is in the affidavit of Benjamin Agena. That is the first limb of the evidence that we submit through Celestine Anyango that shows the deliberate mischief in the use of the statutory forms that was set out in the election and which we now complain of. Going now to the evidence provided by Celestine Anyango in the 41 forms, what was observed is that the forms that the agents have and the forms in the portal are the same in all features. They have the same serial numbers. They are embossed using the same stamps. They're signed by the same agent, presiding and deputy presiding officers. However, the figures in the forms have been tampered with and are different with regards to the results for the first petitioner and the results of the first respondent, William Samoei Ruto. It is in the forms, or the sample of forms, the 41 sample of forms exhibited by Celestine Anyango, that votes have been reduced from the first petitioner and added to the first respondent. We have calculated the total number of votes reduced from the first petitioner and added to the first respondent, and they add up to 2,793 votes. My ladies and my lords, we contend that the figures are important because of the slim margin with which the first respondent won the election or was declared as the winner in the election. And the court, we asked the court to keep a note on that. My ladies and my lords, the difference between the result declared to overcome the 50% plus 1 threshold is 69,000 votes. 0.49%, which is the margin that the first respondent is said to have overcome the constitutional threshold is the equivalent of 69,000 votes. And therefore, when we look at the results and the numbers that we will show have been tampered with, either reduced or removed from the first petitioner's votes, we will show that affect the outcome of the election or the result of the election. We have already shown that there is 2,793 votes removed from the first petitioner to the first respondent. There is also from Kakamega County the example where votes would be deducted from the first petitioner but not added to any particular candidate. The mischief that is also borne out in our affidavits is that the intention was to ensure that the total number of voters remained exactly the same. So, for example, just a minute. I beg your pardon. At page 2 of the affidavit of Celestine Anyango's affidavit, at paragraph 4, my lady, just as an example, in Chepalungu, polling station 1 of 1, the first petitioners and the physical copy of the Form 34A that was given to the agent, the first petitioner had 61 votes. In the form that was uploaded, or that is appearing in the IBC portal, the first petitioner has 1 vote. In the Form 34A of the same polling station, the first respondent, William Ruto, had 109 votes. In the Form 34A in the IBC portal, William Ruto has 169 votes. The 60 votes that are reduced from the first petitioner are added to William Ruto. The total votes remain the same. The same continues in all the 41 polling stations that we have sampled and annexed to the affidavit. Similar to that issue is the evidence sworn by, in the affidavit sworn by Arnold Oginga at page 4 to 13, where he highlights discrepancies in the Forms 34A issued to the petitioner's agents and the ones uploaded by the first respondent, sorry, not the first, the IBC, in the public portal. Arnold Oginga sampled polling stations, 25 polling stations in Baringo, 15 polling stations in Nairobi, and he finds the same results as Celestine Onyango where a total of 1,570 votes are added to the votes of the first respondent, William Samoei Ruto, that are not borne out by the original Forms 34A issued to the agents. From the affidavits or the evidence of Celestine Anyango and Arnold Oginga, we conclude or find that the total number of votes deducted from the first petitioner and added to the first respondent is 4,463 votes. The second issue that I will deal with, my lady, is issue number 4, which is whether the postponement of the gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kachaliba, Rongai, and Pokot South constituencies, and the electoral wards in Nyaki West in North Imenti constituency and Kwanjenga in Embakasi South constituency resulted in voter suppression to the detriment of the petitioners in petition number E005 of 2022. The evidence that we rely upon for this is also in the affidavit of Celestine Anyango, Arnold Oginga, and the affidavit of Ezra Sunguti, who was an agent of the petitioners in petition number E005 of 2022. My ladies and my lords, the first complaint and the issue in this matter is that the elections, first of all, were cancelled only in the strongholds of the first petitioner. That is the consistent theme with all the counties or constituencies where the elections were cancelled. Therefore, as the election started, the first petitioner did not start equally with the first respondent. Ezra Sunguti deposed in his affidavit that polling stations did not open at the stations where he was manning as late as 1 p.m. due to failure of KIMS kits. One of the questions that we want to ask, because consistently the KIMS kits appeared to have failed in the same region, in the strongholds of the first petitioner. It cannot be coincidental that only faulty KIMS kits were sent to the petitioners' strongholds. Ezra Sunguti also testifies in his affidavit that polling started at 2 p.m. and was not extended beyond 6 p.m. despite starting 6 hours later than when the polls were supposed to open. The effects of this: one, the time was not compensated. 2, by the time polling was starting, voters had left the disabled, the elderly, and therefore the turnout in those polling stations was affected. This particular evidence has not been controverted by the respondents. On that ground, again, we submit that the cancellation of the vote in those particular areas suppressed the voter turnout, and this can be seen by looking at the voter turnout in those constituencies as compared to the voter turnout in neighboring counties or neighboring constituencies. We find that there is a vote differential of about 4% or 5% when you compare the turnout in the areas where the election was cancelled and areas where the election was not cancelled. My ladies and my lords, we also consider that the cancellation of the votes of the election in the strongholds of the first petitioner was deliberate because the reasons given by the IBC or the chairperson are not borne out by the statutory provisions for cancellation of the election. We have also sought to corroborate this evidence with the evidence provided by Irene Masit, who is a commissioner, who testifies at paragraph 26 of her affidavit that the reason why the votes or the election was cancelled in those areas was because the commission procured the wrong ballot papers. This is a mistake that Irene Masit, a commissioner...
May I, please, may I, with your very kind permission, Chief Justice, draw the attention of the court that there may be on record more than one affidavit by Ms. Masit, to the extent that the affidavit that my learned colleague refers to is an affidavit filed by the petitioner. We have no objection. However, to the extent that that is an affidavit filed in the documents by Issa Mansour, whose documents our understanding of yesterday's ruling was struck out by the court alongside his notice of appearance, then there ought not to be a reference to that affidavit.
Yes, I think counsel clarified the affidavit she is referring to.
I will clarify to that. Sorry. My lady, I hope the time will be restored to me. My learned senior
There is an error that was stated by my colleague, Professor Ngidu Muigai. The ruling by this honorable court struck out the notice of appointment of Advocate Baisa, not anything else. That is what I heard with my own ears.
If I may please interrupt you.
Counsel, please, without wasting a lot of time, we are capable of discerning what we meant with our own ruling. Let her identify the affidavit she is referring to, and when you are responding, then you deal with the issues that you are raising.
I appreciate that, my Lady Chief Justice, but I think if we proceed beyond this point without a common understanding by all the advocates as to what was the consequence of striking out the notice of appearance, then many on this side may make reference to those documents filed by Issa Mansu. To my own understanding of the law, once the notice of appointment was struck out, all consequential filings based on that were null and void and expunged from the record.
Proceed.
My ladies and my lords, that issue can be put to rest very simply. The affidavit that I refer to by Irene Massit is drawn and filed by MS Ouma J and Associates Advocates. I believe each of the commissioners had a right and did appoint their own advocates in response to the petition, and that is what I am referring to. So Malanid Senior is lost on that one. If I may proceed now. My lady, I do refer to the affidavit now of Irene Massit at paragraph 26 of her affidavit, where she deposed that the chairperson and the commission secretary and the CEO failed to ensure that due diligence was done on procurement, proofreading, and printing of ballot papers, which is also a process that takes place prior to the general elections, and which in turn affected the elections in the areas that we complain the election was cancelled. She lists it, and for time, I will not refer to them. The averment is that the error on which the IBC relies upon, or the chairperson relies upon, that led to the cancellation of the result, was one of willful neglect. Irene Massit further testifies that there was no meeting as was required to be before the procurement was done, or verification to ensure that they proofread what they had procured. And she also testifies that in practice in 2017, this had been done before to ensure that this mistake does not occur. My ladies and my lords, to the extent that that admission is made by a commissioner, we submit that we are supported or find corroboration to our complaint that the cancellation of the vote in the areas in which we have complained about was deliberate and not accidental. The fifth issue that I deal with was whether there were unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. This evidence is found in the affidavits of Celestine Anyango, I beg your pardon. My ladies and my lords, the evidence is found in the affidavit of Celestine Anyango, where she shows at paragraph 8, 9, 10, and 11, where she has produced evidence showing that in 8 counties, there was a discrepancy between the votes cast for the president, votes cast for the governor, votes cast for the senator, and votes cast for the woman representative. The total number of the votes discrepancy is 33,208. And my lady, it is at this point that I reiterate again the slim margin between the result declared for the first respondent, which is 69,000 votes, to attain the 50% plus one threshold. In response to the discrepancy of the votes that we have highlighted, the IBC's witnesses, Sunkuli, Moses Ledama Sunkuli, I believe, states that those discrepancies are accounted for by prison votes. Because prisoners only vote for the presidential candidate. My lady and my lord, if one looks at the total number of votes that have been provided as having been accounted to the prisoners, it is only 715 votes. You will find this at paragraph 53 of Sunkuli's affidavit. There is therefore no account for 32,493 votes. On that issue alone, we would like the court to consider, for instance, in Kirinyaga County, where the discrepancy between the presidential votes and the governor's vote was 23,550, which the only answer given by the respondents is that these were stray ballots. My ladies and my lords, a rough calculation of what is given as stray ballot for Kirinyaga County alone yields 33 stray ballots per polling station on average in Kirinyaga County, which we submit is not possible. This is also the kind of issue or discrepancy that, based on the rules, ought to have been brought to the attention of the National Tallying Center or the National Returning Officer. We rely also upon the authority cited in our submissions of William Kabogo, where the learned Justice Kimaru said a difference of over 5,000 votes between the parliamentary position and the presidential can only be as a result of fraud. My ladies and my lords, would also urge the court to note that at this election, the IBC had provided a clerk whose sole duty at the polling station was to ensure that voters placed their ballot papers in the right box. And therefore, the incidence of such a high number of stray or allegedly stray ballot papers cannot be explained and has not been explained. Finally, my ladies and my lords, as time is not on my side, we urge the court to look at the evidence of Arnold Ochieng Oginga on the discrepancies between the Forms 34A or the results declared in Forms 34A, Forms 34B, and Forms 34C. The design of the election was that this was to be a seamless transaction, and therefore the Forms 34A and the results therein ought to be the same as the Forms 34B and ought to be the same as the Forms 34C. In his affidavit, Arnold Ochieng Oginga finds that there is a discrepancy in the results to the extent of over 180,000 votes. That affects the result of the election or the outcome of the election. I will stop at this particular point and invite my senior, Mr. Paul Mwangi, to continue.
Madam Chief Justice, Madam Deputy Chief Justice, my lords, my ladies, I am to address myself to the sixth issue of the court, whether the IBC carried on the verification, tallying and declaration of results in accordance with Article 138(3)(c) and Article 138(10) of the Constitution. The thrust of my presentation is that the nature of management of elections in Kenya from even before the new constitution have been that decisions as to who has won the presidential election are collegiate, and that the collegiate nature of the decision as to who is the winner of a presidential election goes down to the description of what is a free and fair election under Article 81. And in Article 81(e), the Constitution describes a free and fair election as an election, E3, conducted by an independent body, 4, transparent, and 5, administered in an impartial, neutral, efficient, accurate, and accountable manner. And it is my submission that this goes not to just what the Constitution says, but what Kenyans have practiced and what they have come to expect whenever bodies are making decisions. Possibly more than any other body, the judiciary has been able to show Kenya the nature of collegiate decision making. We have had live court sessions from the High Court to the Court of Appeal to the Supreme Court. Kenyans have seen often the presiding judge, in this case even the Chief Justice, consult even sometimes openly with other judges before the court arrives at a decision on even very small things. And we have even had situations when a decision becomes grave. We have seen judges retire to go so that they come back with a collegiate decision. So that is what Kenyans have come to expect, and that is also what Kenyans expect even from the Independent Electoral and Boundaries Commission. First, the nature, our commissions are made up of at least 3 members and at most 9. And if you look at the qualifications of all these members, they are all, whether it is the chairman or the members, largely have the same qualifications. They are all identified and recommended for appointment among the same criteria. They are all approved by the National Assembly. They are all appointed by the President. So there is no basis on which the chair of any commission can treat as subordinate members of that commission or treat them as if they have lesser qualifications or lesser competencies than him. They all enjoy the same security of tenure. They all enjoy the same security in their remuneration. And so they are all expected to execute very substantive mandates. My Lord, this question as to the mandates of commissioners came up in the case of Michael Kamau versus the Ethics and Anti-Corruption Commission, which is in our list of authorities, came up in the High Court and came up in the Court of Appeal. And the court, both courts were very categorical as to the fact that the constitutional mandate of a commission is borne by the commissioners. And in that case where a commission had attempted to reach a decision without commissioners, the court annulled that decision and said that that decision had to be made by commissioners. And in respect of the powers of a chairperson, again, the minor KI case all the way from the High Court to the Court of Appeal and to this court have made it clear that the chairperson is not the commission and that he has to act with the rest of the commission for him to deliver a proper constitutional decision. So that collegiate nature of the decision making in a commission is captured very well in Article 138(3)(c) and in Section 39(1)(c) of the Elections Act, would make it very clear that it is for the commission to tally and verify the results. And in Article 138(10) is only where the chairman is asked to declare the result of that decision. And our submission is that the requirement to declare does not give the chairman any power to tally, to verify, or even to reach a decision as to what he is going to declare. That part of the Constitution was first captured in Section 41 of our previous Constitution in subsection 11, which had a proviso that provided any decision of the commission shall require the concurrence of a majority of its members. And that is why I say the collegiate nature of decision making at the Electoral Commission even precedes our new constitution. And at that time, there was an attempt, which I will submit is an attempt that has also been made this time by the chair of the Electoral Commission, to take away that collegiate nature of decision making at the commission. And if you read the Kriegler report, which is also next to a list, it talks of an attempt at that time, or actually an actual creation at that time, of an office that was called the Supervisor of Elections. And the Supervisor of Elections was an executive office that was used to undermine the independence of the Electoral Commission of Kenya. And as we moved to the first multi-party elections, one of the first insistence that Kenyans had was that the Supervisor of Elections must be removed and that decision-making regarding elections must be taken back to the ECK. But that was not even enough, because Kenya still felt then that Section 41 was still not clear enough. And in Act number 6 of 1992, which preceded the first multi-party elections, Kenyans insisted that the mandate of the commission be made clearer, and we now promulgated Section 42A into the old constitution. And Section 42A made it very clear that the Electoral Commission shall be responsible for directing, supervising presidential, national, and local government elections. So by the time we were coming to the new constitution, we had already taken a position that decisions regarding presidential elections have to be collegiate. When the new constitution itself was being promulgated, there were several options that the framers of the constitution could have. They could go back to making this is the decision of an independent office, as Mr. Afula Chebukati has attempted to act. But instead, they created, for the first time, what they called independent offices, created the DPP, the Auditor General, and Controller of Budget as independent offices, but found it wise to retain the collegiate nature of decision-making as an act of the Commission. The question then we asked is, why is it necessary for there to be a collegiate nature in the decision-making regarding presidential elections? I said, one, it's because it gives integrity to the decision. And the more important a decision is, the more it may require more people to make it. And we see that also in our court system, where decisions are made in the High Court by one judge have to be made by 3 in the Court of Appeal and have to be made by 5 at the Supreme Court. And this is even being seen in sports today, that in very important matches, they have even moved away from leaving critical decisions to one referee. And we have now gone to even video-assisted refereeing so that more people can weigh in on a decision that is that important. The second thing is that the collegiate nature secures the independence of the Commission itself, so that you don't have one person who can be in a position where they cannot resist maybe pressure. And therefore, so long as we know that there are 7 people making this decision, we are more confident about its independence. But thirdly, my lady, my lords, there is also the question of the legitimacy of the decision. And this comes from what this court said in 2017. And in paragraph 371, in the case of Raila Odinga versus IEBC, the court says that elections are the surest way through which the people express their sovereignty. Our constitution is founded upon the immutable principle in the sovereign will of the people. It says that, in fact, it is the people and they alone in whom all power resides, be it moral, political, or legal. And so they exercise such power either directly or through their representatives, whom they democratically elect in free, fair, transparent, and credible elections. Therefore, whether it be about numbers, whether it be about laws, whether it be about processes, an election at the end of the day must be a true reflection of the will of the people. And I view legitimacy in 2 ways. That first, it is very important for Kenyans to believe that the decision has been arrived at is legitimate. And the reason for that is because it is in one person. They have been asked to delegate their sovereign authority. So they believe that a decision has been reached that is legitimate is very important. And you see that in Article 131, that political legitimacy of that decision is covered in Article 131 of our Constitution. Because Article 131 gives our president 4 powers. He makes him the head of state and government in paragraph A. In paragraph C, it makes him the commander-in-chief. In paragraph D, it makes him the chairperson of the National Security Council. And then in paragraph E, it makes him the symbol of national unity. So of all the 4 things that our president must do, the A is the political legitimacy. And if decisions are arrived at as to who has won an election, and they do not carry with them the legitimacy that is required, then you have somebody who cannot exercise the duties, execute the duties under 131E as being the symbol of national unity. But there's a second reason. And the second reason is that also the person to whom you now declare as the president must himself believe in the legitimacy of the decision that has been made. And political scientists say that This political legitimacy is necessary because it finally determines how that person themselves will hand over that power. And political scientists say that power that is unjustly acquired will never be justly given. So if you want to have a legitimate transfer of power in a country into the future, you must ensure that that power is also known not just to the public, but to the person who acquires it as legitimately obtained. The question then comes to where we find ourselves today, where we have the chairman and a minority group saying they carry the day in this decision, and we have 4 commissioners. And the question this court has to ask is who would it believe? And it's our position that Mr. Wafula Chebukati has disrespected the Constitution, has been unable to secure the legitimate result of an election that was conducted. And in terms of deciding who to believe, my lord, first and foremost, Mr. Wafula Chebukati has not had a complaint to make as to how these 4 commissioners worked ever since they entered the commission in September 2021. On the other hand, there are lists of complaints as to how he himself has conducted this election that start way back from 2017, that he bungled up the 2017 elections. We've captured in a petition that he has had 4 other commissioners resign on him previously. There's unilaterally printed ballots. He's unilaterally made decisions about use of registers, and in our both affidavits and petition, we have made a list of all the misconduct that he himself has executed. And the result of all that, you come to the conclusion that what the chairman has attempted to do is to install himself as a new age supervisor of election, totally emasculate the role of all other commissioners, and you now have a decision that is his, supported by a minority of the commission. And our argument is that that declaration is not a constitutional declaration. That declaration is unable to found the declaration that was supposed to be made under Article 131(8). And one of the most glaring things that comes also from that conduct is the issue of the 27 constituencies. And the 9th respondent knows the importance of that, because in paragraph 6 of his affidavit, he purports that those results were read. He purports that, in fact, that the disaffected commissioners announced those results. But the affidavit of Professor Goulier and the response of Chebukati themselves clearly say that those 27 constituencies were not verified and announced. And the reason for that, according to the 4 commissioners, is because he emasculated the role of the other commissioners and they never sat down as a commission. I will finish my presentation as to the unconstitutionality of that declaration with 2 examples. We have had previously a situation such as this in the Truth, Justice and Reconciliation Commission. I'll ask the court to take judicial notice of what had transpired as the commissioners fought with their chairman regarding what was the report of the commission. And it was very clear that the report of the commission had to be what was decided by the commissioners. But I will also leave this presentation with something closer home, my lady. In the past couple of years, there has been a dispute between the executive arm of this country and the judiciary regarding who makes the decision as who becomes a judge. And it has been the position of the national executive that the power to appoint comes with it with some form of power to decide. And this judiciary has been very clear all the way from the High Court to this court that the power to appoint in no way includes a power to decide on who becomes a judge. I say that for the same reason, the power given to the chairman of IEBC to declare the result of an election in no way gives him any power to decide what that result will be. And if we cannot be shown how the commission as a commission reached a decision or reached the decision that was pronounced by its chair on the 15th of August, then I implore this court to use the same reasoning and tell the chairman in the same voice that it has told the national executive that your power to declare does not give you any power to decide on what you declare. That is all, my lords.
I haven't been in the court, so good morning, your ladyships and my lords. My humble responsibility today is to deal with technology, and that is covered in the issues that were framed by the Honorable Court as 1, 2, and partially issue number 3. I have been listening to the submissions of my learned colleagues, and I will try not to repeat any of them except where absolutely necessary. I start by referring to Article 86 of the Constitution. 86 provides for voting, and I particularly refer to 86A. The method, the voting method, must be simple, accurate, verifiable, secure, accountable, and transparent. I also read out to the court Section 44 of the Elections Act, which provides for the use of technology. How this has evolved is a matter that has been addressed by my learned friends and is well known to the court, particularly this court that has rendered decisions in the same regard. Section 44 of the Elections Act provides that the use of technology in an election should be an integrated electronic electoral system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. Section 39 of the Elections Act provides for the determination of the declaration of presidential results. And in this regard, it provides at 1C, for the purposes of a presidential election, the Commission shall, A, electronically transmit and physically deliver the tabulated results of an election for the president from a polling station in the constituency tallying center and to the national tallying center. Regulation 14 of the Elections Technology Regulations 2017 provides as follows. Information security. The Commission shall put in place mechanisms to ensure data availability, accuracy, integrity, confidentiality, as set out in the first schedule. The court is aware of Raila Odinga and another versus IBC 2017, where at paragraph 231, it provided and underscored the objective in the above laws. I will not belabor that. The technology envisaged by Section 44 of the Elections Act was intended to ensure an integrated and secure tallying and data transmission system which would allow computerized data entry tallying at constituencies, secure simultaneous transmission of individual polling stations, station level data to the National Tallying Center, and the integration of the results handling system in a progressive election result announcement system. Two words that bear emphasis there is simultaneous and progressive election result system. Our submission in this regard is that the technology deployed by the IBC for the conduct of the 2022 general elections completely failed the standards of a secure, transparent electronic voting system, and thereby yielded what has aptly been described by my colleagues as an unverifiable, inaccurate, and therefore invalid results. Our further submission in this regard is that the technology was so inherently corrupted, manipulated, and tainted that the results declared by Mr. Chebukati, the third respondent, cannot be in an objective case said to be representative of the true will of the Kenyan people, as we and as I will demonstrate in my further submissions. On the evidence, the components, principles that ought to have been met in order to meet the constitutional standard of a secure and transparent system are as follows. Confidentiality is the first one I propose to deal with. This requires that the information within the process, and I'm not talking about the public portal, talking about the back end, should have been accessed by only those legitimately authorized. And those authorized, in order for them to be accountable, are persons whom the entire commission, in its, as defined by my colleague Paul Mwangi, the entire commission ought to have been fully aware of, gazetted where necessary, and it would certainly help if they were also Kenyan nationals. Integrity is the information used should be accurate, complete, protected by various and protected from malicious modification, which includes alteration or obstruction, either by authorized or unauthorized persons. Availability. The information required must be available as and when required by those authorized to use or access it in compliance with the constitutional requirements and the Elections Act. Non-repudiation, an audit trail must be maintained on activities related to the information. An audit trail in this regard is, should the court so require, should a party so require, it must be readily available in the appropriate manner. Authenticity. The information itself must be proved to be genuine, and the source must also be proved to be genuine. I submit on behalf of the petitioners that on the security aspect, there was lack of security. The first instance of that demonstrates this is the operation and use of the IBC and availability to, I repeat that again. The first is operation and use of IBC election materials and equipment to identified unauthorized persons. And I'm referring in this regard to the now infamous Venezuelan nationals. I will elaborate on that. in a few seconds. The second is the penetration by way of hacking and illegally granted access of the IBC system by known and unknown persons. I distinguish between hacking and unauthorized grant of access. Hacking is where a person outside the system doesn't have the key, and I'm using the simple illustration, and so he accesses it through the roof, a room through the roof or the back door, and he enters the system. The illegal grant of access is a situation where the codes, the credentials that are otherwise legitimate are granted to unknown persons. In the case of the now infamous Venezuelans, there is plenty of affidavit evidence on record, and I particularly refer to the affidavit of Martha Karua, the second petitioner, dated the 21st of August 2022, which contains or encloses the statements by the DCI, and of course the rebuttal by Chebukati on behalf of the IBC. Your Ladyship, my Lords, I also refer to the affidavit of Juliana Cherera. I also refer to Annexure JC3, the National Police Service press statement dated 22nd of July 2022. Annexure JC4, press statement by ABC Chairman dated 21st July 2022, stating that the 3 key personnel responsible for the deployment and management of elections infrastructure, and that the 3 Venezuelans were employees of Smartmatic International BV. I also refer to the Annexure JC5, press release by the Directorate of Criminal Investigations dated 23rd of July 2022, detailing the crucial election materials irregularly and illegally found in the possession of 3 Venezuelan nationals. Their names: Jose Gregorio Camargo Castellanos, that is one name, one person; Joel Gustavo Rodriguez Garcia; Salvador Javier Sosa Suarez. Those were the persons named in the detailed Directorate of Criminal Investigations report. My Lords and Your Ladyships, I would like to emphasize that the Directorate of Criminal Investigations is the national institution charged with the responsibility of investigating crime. Crime in relation to the Penal Code, the Elections Act, all crime. And that evidence, the statement by the DCI regarding the Venezuelans, is not a matter that can be taken lightly and wished away by the chairman of the IBC. I will deal then with the issue of the penetration or the compromise of the IBC system. And I ask the court to look at the affidavit evidence of John Mark Gidongo, 2 affidavits or 3 affidavits, Benson Wesonga, an IT forensics expert, George Njoroge, IT forensics expert, and the forensic analysis of the DCI of a laptop confiscated from one Kip Ngosos at the National Tallying Center. I also asked the court to look at the affidavit of Justus Nyangaya, who is one of the commissioners. Which responded? Sixth respondent. Thank you. I will summarize the affidavits. The evidence of John Mark Githongo, he has sworn 2 affidavits, one on the 21st of August 2022 and the other on the 28th of August 2022. In his affidavit, at paragraphs 2, 3, 8, 9, and 10, he talks about the illegal access into the system and manipulation of the presidential results, how it was orchestrated and implemented. At page 4, paragraph 12, he produces evidence of a video recording. Paragraph 8, page 8, paragraph 16, he witnesses how he saw this young person illegally and very easily access the IBC system, where he was able to see information including that of his name and other accredited observers at the IBC National Tallying Center, and pages 13 and 18 of certain screen grabs. In the affidavit dated 28th August 2022, page 2, paragraph 4, John Githongo clarifies what was given to him in the first affidavit, but more importantly, at page 2, paragraph 6, he produces the actual logs that were used to show access to the system. I wish to make a short submission regarding the evidence of John Githongo and the transcribed interview he had with this young person. And I'm discussing this in the context of the probative value of that conversation he had with this young witness. It came out that somewhere, somehow, in the Karen suburb, there was a group of about 50 people who had access to the ICT systems of IBC, whereby they were intercepting results before they were uploaded on the public portal. When that was put out and the responses first came, that suggestion was rubbished. But in further evidence, I will demonstrate to the court that it now turns out that that is probably and most likely what happened and what created this entire mess that is called the election results of the 2020-22 presidential election. In the case of George Njoroge, whose affidavit is on record, whose CV is on record, a computer forensic expert with wide-ranging experience in investigating all manner of crimes, including those involving terrorism, through investigating the IT aspect. In his affidavit dated 28th August 2022, he has attached his detailed audit and analysis report of IBC results transmission system and operating system log files. And I emphasize that amongst those he analyzed are the logs annexed to the affidavit of Justice Nyangaya, who is the 6th respondent and who was the commissioner of IBC in charge of ICT. I emphasize this because it tells us the logs, that information from the logs comes from within the IBC, the first respondent. And therefore, it must be taken as correct. Indeed, in one of the witness statements we have, or affidavits we have from one Mr. Nyaga, in various affidavits, together with Mr. Uma, they are defensive. Together with Mr. Chebkati, they reject the suggestions. But when the logs from Mr. Nyangaya are finally analyzed, they are suddenly, in particular Mr. Nyaga, forthcoming. In the case of Mr. Nyaga, and I will refer to his affidavit, his first reaction is to suggest that they have been illegally obtained and a crime has been committed and somebody should be prosecuted. In fact, the DCI should take action. That is an admission that at all times something vital to the verification of the process was being withheld, not only from this court, from the entire Republic of Kenya. George Njoroge has provided a detailed audit and analysis report, and he, at page 1, paragraph 5, confirms that he analyzed the log files. Page 11 shows the image application for each of the 6 IEBC servers that had information. And of course, at this point, I'm hopeful that in the scrutiny, the same 6 IBC servers shall be availed by the IBC as quickly as possible. Page 3, which is the part of the report that confirms several authorized individuals were illegally authenticated to gain access into the core of the live system. Several authorized individuals were illegally authenticated. We'll go and demonstrate that, because authorized could mean you're within IBC, but illegally authenticated, you have gone well above your pay grade. Page 14, 40, page 14 of the report, 14, 40, and 41, confirms that there was evidence of remote access to the system on the 13th of August 2022. 13th being 3 days after the voting. Remote access means somebody outside the walls, virtual walls of IBC. In other words, somebody somewhere sitting out of the system has the key and can log in. Transmissions of numerous forms from a single host server whose IP address was given or is given as 172 full stop 21 full stop 5 full stop 4. Contrary to the expectations that the forms would come from various KIMS kits directly to the NTS public portal. I illustrate this, or I explain this by stating that Mr. Chebukati, chairman, went on record as saying this is a very simple system. From the constituency level, it shall come to the National Tallying Center, onto the portal that is public. He has no intervention whatsoever. He can't stop it. It comes. To the extent that I remember one conversation in one press statement, he was asking the press, why are you so slow? You know, I'm faster than you. But that is how it was supposed to happen. But the evidence will show that we have provided that there was an illegal, malicious, and unauthorized existence of commission staff who are not officially gazetted and mandated to be part of the electoral process, but who had access. Page 15, and one of them I should state now was his personal assistant, whose name I shall provide shortly. Page 15 shows that there was evidence of, this is important, there's evidence of downloading and conversion of the forms from the system and thereafter uploading them with new information. Your Ladyship, my Lords, I explain this by saying a Form 34A has been uploaded from the constituency level by the returning officer. Before it hits the front end of the public portal, meaning the side that we will all have access to, it is downloaded, it is changed, converted into a system known as CSV, which is comma separated values, that's what it means, which is an editable format from the original PDF format. PDF, we all use that abbreviation without getting what the meaning. It means portable document format. The PDF cannot be edited, whilst the CSV provides the opportunity, the facility for editing. So if one were minded, that is the point, and we submit that is what happened when the numbers are changed. within the Form 34As. Otherwise, there would have been no need for downloading the system, the documents, and uploading them after after a bit of time, sometimes hours, sometimes a few seconds. Page 16 and 21 shows a continuous generation and regeneration of 35C, yet 35C was 34C, yet 34C was supposed to be generated only once at the very end of all the information from 34B coming in, and of course 34A. Page 17, this is an important component of our submission. There was overwhelming evidence of back-tallying of presidential results. This means that a Form 34C was being generated with a result, a desired result, and thereafter what seems to happen is a process of going backwards to change Form 34B and 34A to give the result that was desired. This happens continuously, and it is illustrated very well in the evidence of Mr. Njoroge. What is obvious but bears repeating is that the process, the system was only supposed to work forward going, not by way of back tallying, meaning 34A, the aggregate of the 34A was to create the 34B, and the 34B aggregate would create 34C. Once 34A, as many as there are polling stations, etc., going forward. But what you see from the report of Mr. Njoroge is after the voting, until the results are announced, far too much activity, all starting with the generation of a 34C. The analyst is not able to know exactly what is going on.